Hello and welcome to Bloomberg Quint. You're watching Insolvency Diaries. The latest proposed amendments to the Insolvency and Bankruptcy Code promise to restore the creditor hierarchy, ensure speedy resolution of cases, open up structuring possibilities in resolution plans, and make plans binding on the government and local authorities. To discuss the implications of some of these changes, joining me today is Nilang Desai of AZB and Sudipta Routh of IndusLaw. Nilang, Sudipta, welcome to Insolvency Diaries. Nilang, the first key change is a clarification that a resolution plan may now include provisions for restructuring, and that could include a merger, an amalgamation, or a demerger. What was the need for this clarification, and what kind of possibilities does this now open up that didn't exist today?
Sure. So I think the ability to reference the next step of a demerger or merger was always there, and plans did that already. What the statement of objects and reasons is saying is now, with this clarification, you can put in provisions in relation to this as well. So the suggestion seems to be that you can actually put in the active provisions of a demerger merger in your plan. Now, I think a few things have to be thought about. The timing of that, the feasibility of that. You have only 9 months to run the process. You know, on the one hand, you're doing a resolution plan. On top of that, you have to think about the various consents and processes and timings and stakeholders involved in a future merger process which you want to bring into this. So I think that needs to be worked out. But if it's possible, I think what the law is saying is put in the provisions over here as well. It's the same court. Try and get both consents together, which will be difficult given the practicalities of it. But certainly the possibility is there.
So the plans, let's say, that you have seen haven't envisaged any of these restructuring so far that, let's say, are in the works or probably have come to courts?
They have envisaged it as something they will do,
okay,
but not as a one-stop shop for both the IBC resolution plan and a demerger and a merger.
Okay.
Not that I've seen anyway.
Okay. So, Deepta, are you seeing this as a one-stop shop clearance of sorts for restructuring, that can now be built into resolution plans?
No, not at all. Because what they're doing is, if you notice the wordings, they're saying for removal of doubts. There was actually no doubts that you could put in demergers, bolt-on acquisitions, you could put on amalgamations through a code-driven process. You could do all of that in your resolution plans. There were certain doubts which were expressed by resolution applicants as well as the COCs as to how is this to be implemented. Will the approval of the NCLT of the resolution plan mean that this is whitewashing the entire process under a different statute, which is the Companies Act? The answer is no. You do put in whatever steps you can into the resolution plan. It's for the COC to then evaluate the feasibility and viability, and that language is there in 30, I think. And you're supposed to look at that and you're supposed to say, okay, we could go ahead with this, but we don't believe that this is viable or this is feasible for you to get this consent or that consent. So what they've really done is remove that doubt, in the sense that you can definitely put it in, you can say what you want about it, and you leave it to the COC to make that judgment whether this is feasible, and it's not a one-stop shop, for sure.
Okay, so two questions. One, I can now sort of envisage a merger or a demerger, etc.
Yeah.
Can that process, A, run parallel to the insolvency process? Or two, when let's say I get a stamp of approval from the adjudicating authority on my resolution plan, do I then restart that process of amalgamation, merger, and seek approvals thereon?
Yes, it does mean that when you do go to the court and file a petition for amalgamating a composite scheme for amalgamation, demergers or whatever, that's what you'll usually do. The resolution plans I've been seeing, if they have a demerger, an amalgamation, they try and make a composite scheme. And I've seen a resolution plan which actually has a draft scheme with it. But the point is, you can't go and present that petition without the requisite shareholders meeting, creditors meetings of other entities as well, right? So as long as the CIRP is continuing, and that ends when NCLT says this plan is approved by the COC and here's our order, that's when you go and make the filing. Now, can you get sort of consents from the other shareholder groups, the third-party stakeholders? Yes, you can. There's also been a lot of debate in the IBBI in the last 6 months at least how do you arrange for pre-packs? Pre-packs has been a bit of a topic in the recent past, where you actually go with a scheme and you say that, here, this is my scheme, and or if you had a JLM in your company before you went to the CIRP, you already have a resolution plan there. You go with that pre-pack, and you say that this is my resolution plan, and all that is pending, therefore, is really filing the petition in the NCLT. And you can't do that because you don't know if your resolution plan is approved until the NCLT passes the order.
Sure, okay.
So that's the sort of trail.
Okay, Nilang, are you also reading it as, what Sudipta explained, that you will need the requisite shareholder approval of the concerned, let's say, a subsidiary that you're planning to merge as part of the resolution plan? You will need to seek separate shareholder approval and the requisite approvals even after the resolution plan is approved as part of the CIRP process?
Of course. I mean, there is no doubt that this is not allowing you to ride over the consent requirements of a third company which is being merged into this.
Okay.
The question is whether the courts will interpret this to say, I will try and do these processes simultaneously. So when you leave my court, you have both. Is that going to be feasible and practical is the question.